What happens to my Virginia car accident case if I'm even 1% at fault? In most states, being slightly at fault for a car accident reduces your compensation. But in Virginia, even 1% of fault can eliminate your right to recover anything at all. Virginia follows a legal doctrine called pure contributory negligence, one of the strictest fault rules in the entire country. Applied by only 4 states and the District of Columbia, unlike comparative fault states that simply reduce your damages by your percentage of blame, Virginia's all-or-nothing approach means that any contributing fault on your part can bring your recovery down to zero. Insurance companies know this rule extremely well, and adjusters actively search for any evidence of shared fault. Whether a slight lane drift, a moment of distraction, or a few miles per hour over the speed limit, even seemingly minor details can become the foundation for a $0 settlement offer once an insurer decides to raise a contributory negligence argument against you. The critical question is not what percentage of the blame belongs to you, but whether your conduct legally contributed to causing the crash at all. Fortunately, Virginia law does recognize certain doctrines that can preserve a path to recovery even when you share some responsibility for the accident. The last clear chance doctrine is one of the most important escape valves from Virginia's strict contributory negligence rule, applying when the other driver had a realistic final opportunity to avoid the collision and failed to use ordinary care. For example, if you were stalled in the roadway and the other driver saw you in time to stop or steer away but chose not to act, that driver may still bear full responsibility despite your initial negligence. Virginia courts have long recognized this doctrine, and whether it applies depends entirely on the specific facts of how the crash unfolded in the moments before impact. A second exception arises when the defendant's conduct rises beyond ordinary negligence to the level of willful and wanton misconduct, which involves a conscious disregard or reckless indifference to the likelihood of serious harm. When a defendant has acted with that level of recklessness, Virginia law may prevent them from using your contributory negligence as a complete shield against paying damages. Both the last clear chance doctrine and the willful and wanton misconduct exception are deeply fact-specific, which means early legal guidance is essential to identifying whether either applies to your situation. Acting quickly after a crash also helps preserve critical evidence, protect the record of what happened, and position your case before an insurer's fault argument hardens into an outright denial. The attorney you work with can review insurance communications, evaluate how Virginia's contributory negligence rule affects your specific claim, and help you understand your legal options before time runs out. Virginia law generally gives injured people a 2-year window to file under V. Code Section 8.01, 243. But waiting too long to seek guidance can cost you evidence and leverage that cannot be recovered later. A skilled car accident lawyer understands that contributory negligence arguments are often raised strategically by insurers to avoid paying valid claims, and those arguments deserve a strong, informed response. If you or someone you love is facing a contributory negligence dispute after a serious Virginia crash, the law firm of Fishwick and Associates plc is ready to review your case and help you navigate what comes next. Contact Fishwick and Associates plc, located at 30 Franklin RD SWC 700, Roanoke, Virginia 24011, United States, by calling 540-345-5890 to schedule your consultation today.